I'm Shane Morris with the Colson Center for Christian Worldview. In 1916, the U.S. Congress passed a law saying the Supreme Court of the United States would convene on the first Monday of October. It has done so every year since. This Monday, October 7th, the court will begin its annual session. Now, the Supreme Court's decisions are always important, but this year promises to be particularly interesting if you care about life, marriage, religious liberty, and related issues. That's why we wanted to bring Elizabeth Slattery to the BreakPoint podcast to give us a preview of the upcoming session. Elizabeth Slattery is a legal fellow at the Heritage Foundation's Edwin Meese Center for Legal and Judicial Studies. In that role, she analyzes cases before the Supreme Court. She also studies judicial nominations and the proper role of the courts. Her work includes testimony before the U.S. House of Representatives, and her commentaries have appeared in the Washington Post, the Washington Times, National Review, and U.S. News and World Report. She also hosts SCOTUS 101, a podcast breaking down what's happening at the Supreme Court. Elizabeth Slattery gives us a preview of the upcoming Supreme Court session in this conversation with the president of the Colson Center, John Stonestreet.
Well, welcome to the BreakPoint podcast. We are facing now another term at the U.S. Supreme Court, and as we have talked about on all kinds of levels at BreakPoint and on BreakPoint commentaries, there have been a lot of cases that are of interest to Christians. Just recently, Elizabeth Slattery, who's a legal fellow and appellate advocacy program manager for the Meese Center for Legal and Judicial Studies. And let me just say, Elizabeth, that's one great title right there. She is at the Heritage Foundation. She researches and writes on the rule of law, separation of powers, civil rights, and other constitutional issues. And at the Heritage Foundation, and we'll link to this on our website, which is breakpoint.org, she's written a piece basically overviewing what we can expect from this 2019-2020 term of the U.S. Supreme Court. So, Elizabeth, I'm just really glad that you are able to come on and help us think through this.
Thanks for having me.
So let's start with, the cases that have been the most high profile of interest for people of faith have been these cases that have been these collision cases between sexual freedom and religious liberty. And obviously the Jack Phillips case, Masterpiece Cake Shop, and it looks like we have another one of those types of cases, maybe more than one, that we're looking at in this term. Can you walk us through that?
Sure. So there have been a number of cases related to the Masterpiece Cake Shop case, similar cases involving florists and other people working in the wedding industry. None of them are currently before the Supreme Court, but I think there is a chance that one of those could come up later in the term. But a sort of related issue is involving the federal law that prohibits discrimination in employment on the basis of sex. Now, there are three cases that are coming up. They're going to be argued the second day of the term, so in just 2 weeks. And two of them involve claims by gay men who were fired, who then brought suit against their former employer saying we were fired because of our sexual orientation, and that is prohibited under federal law. There's a third case that involves gender identity rather than sexual orientation. Now, the employers in all of these cases say, look, the federal law says sex discrimination, and sex discrimination does not include sexual orientation or gender identity. And until just a few years ago, all of the appeals courts that heard cases like these agreed and said that sex does not include sexual orientation or gender identity. But a couple of appeals courts have gone the other way now, and so there is a circuit split, and the Supreme Court is going to take up those cases on the second day of the term. And really what's at stake here is, I think the broad issue is, what branch of government is the appropriate one to address this issue? If the people decide that they want federal employment discrimination protections to cover sexual orientation or gender identity, should it go through the courts or should it go through the more accountable branch of government? Should it go through Congress? And, it's my hope that a majority of the Supreme Court will recognize that this is policymaking and that if people want this to be prohibited by federal law, it needs to be a change enacted by Congress rather than by the judiciary.
And what we're talking about here is how we understand the word sex in Title VII of the Civil Rights Act of 1964. And I guess one of the long-term implications, and tell me if I'm wrong here, Elizabeth, is that if the court does decide that this word sex, which clearly wasn't on the minds of anyone who produced the Civil Rights Act of 1964, should include sexual orientation and gender identity. I mean, I think, authorial intent here is probably pretty clear, right? So if that was never on the minds, does this have implications for other federal legislation, and not just Title VII, but also Title IX, Title X? This is going to have a ricochet effect, right?
Yes, certainly if the court rules on it, it could have a ripple effect touching on other civil rights laws. As you mentioned, this could potentially dismantle sex-specific bathrooms, and, as we've seen conflicts with individuals, gender identity becoming a problem in athletics, particularly, we get to a situation where young girls competing in high school competitions are then competing against biological males who are identifying as females. That's another reason why it's better for Congress to address this issue if the American people feel like that needs to happen, that Congress can craft legislation that can take account of, religious exemptions and all of these other sort of attendant effects of federalizing these sorts of protections, something that the Supreme Court would not be able to do in a ruling in these cases.
I don't know how much you're into making predictions about these things. Predictions about the Supreme Court are famously wrong, right? So, so we're all a little bit hesitant to do it. But it seems to me that at least over the short term, we have a little bit of a different court than we have had in the past, specifically since some of these. Well, since the Obergefell decision, right, that came from Justice Kennedy. Justice Kennedy, to me, seemed quite reticent to make any sort of sweeping ruling that was going to be a sort of new Roe v. Wade. Now, Obergefell came pretty close to that, but he seemed hesitant in Windsor, and then, of course, he turned around and walked back. I think some of the implications from Obergefell in the Masterpiece decision, basically saying, okay, this is where America's headed, but you can't be mean about it to the Colorado Civil Rights Commission. Is there a reticence on the Supreme Court to kind of redo the sort of culture war creating legislation that Roe v. Wade did?
Yes, I think a number of the justices are aware of what the general reaction and the outgrowth of Roe v. Wade was, that, Justice Clarence Thomas is the only justice who has written on the Supreme Court saying that he thinks Roe v. Wade should be overturned. The others, haven't had the opportunity to say whether or not they agree with that. But I think there is a recognition among particularly conservative members of what came out of taking that policy issue away from the American people, taking it away and giving it to judges instead to decide how to deal with these policy issues. And so I think a number of the justices are concerned about those sorts of, they take that into account. And I think that will certainly be in their minds when they're looking at the Title VII cases.
Well, we've talked about the Harris Funeral Home case. That's the one that involves gender identity rather than sexual orientation. Will the court consider all three of these cases together, or are they going to handle these one at a time?
So they're all being argued on the same day. The two sexual orientation cases have been consolidated, and the Harris Funeral Home, the gender identity case, is a separate standalone case. But I think there could still be two separate opinions that come out from the three cases, but I think they will likely, rise and fall together.
Okay. Well, let me ask you this. Speaking of kind of the sweeping Roe v. Wade, obviously we've seen enough Handmaid's Tales protesters, to last us for the rest of our lives recently. But, that's been the narrative of Gorsuch and Kavanaugh being on the court, that Roe v. Wade is threatened. There's nothing coming up in this term, at least, as far as I can see, that plays into that narrative, at least at this point. Is that right?
I think that's right. And, we heard a lot of really incendiary things when Justice Gorsuch was nominated and then when Justice Kavanaugh was nominated. And so far, the rapid destruction of America that their opponents foreshadowed has yet to occur, and I don't think it's likely to happen. Obviously, if there is an abortion case that comes up, that will be perhaps one of the most closely scrutinized cases to come up to the court in recent memory. There are a couple of petitions right now pending before the justices. Most notably is a case out of Louisiana dealing with whether doctors who perform abortions have to have admitting privileges at a nearby hospital. If this sounds familiar to listeners, that's because the court heard a similar case from Texas a couple of years ago in the term when Justice Scalia passed away. And when the court was shorthanded by one justice, they ended up ruling for the challengers and striking down the Texas law, finding that it was an undue burden on women's access to abortion. Now, the Louisiana law had already been passed at this time, but it was sort of put on ice because it was being challenged in court. It hadn't gone into effect yet. And so now that one there's a petition before the Supreme Court to review that law. And I think there's a good chance the court could decide to take up that case on the merits. Earlier this year, Chief Justice Roberts, along with the 4 liberal members of the court, granted the clinic's petition for a stay of the lower court ruling, which the lower court ruled in favor of the state's law. And so the court said, we're going to grant the stay. The law is not going to go into effect. And, that's kind of extraordinary relief. It's not something they do in every case. So I think that kind of signals that they may end up taking that case on the merits. And, I think if we see an abortion case at the Supreme Court, I think many in the mainstream media it'll be, a 4-alarm fire, all hands on deck. Everyone's going to be trying to influence any of the justices to get them to strike down this eminently reasonable law.
Right, it is. And this kind of underscores, too, something that we've been arguing, which is essentially that, listen, you're not going to have any sort of sweeping reversal of Roe v. Wade. It's going to be taken on, kind of incrementally. And this has to do with undue burdens placed on women, what fits into that category and so on. So it's really interesting. And as you mentioned in your article, and I really appreciate it, by the way, at the beginning, a lot of folks just don't know how the Supreme Court works. I don't know as much as I really should about this. The court receives roughly 7,000 petitions every term, agrees to review between 60 and 70 cases. They've granted review in 42 cases, so there's another 20-odd cases that should fall into the schedule here, depending on how the schedule works out. And one of the things also you point out, too, is that, whenever a nomination process happens, and especially with Kavanaugh and Gorsuch, which was extremely culturally loud, as you mentioned earlier, there's this assumption that, the judges are going to be the puppets of whoever nominated them. And justices have really turned out to be remarkably unreliable as being puppets of the president, it seems. They often don't play by their nominations rule as far as that goes. And you said the same thing about Kavanaugh and Gorsuch. Talk us through a little bit about what you've seen there.
Sure. So the data set on what kind of justices Gorsuch and Kavanaugh are going to be in the long term, it's limited at this point. We have a couple of terms for Gorsuch. We have almost a full term with Justice Kavanaugh. But what we know so far is that they are independent, impartial. They have very distinct views of how they approach the law. And, they're not cookie-cutter Republican judges, if you want to say that there are such a thing as Democratic or Republican judges. For example, they ended up disagreeing in 30% of the cases last term. So, when people assume that they're just going to vote in this monolithic block of conservative justices, that kind of skews how the justices approach the law. To be quite frank, the more liberal wing of the court tends to vote as a block. The Republicans, the liberals are able to peel off one conservative here, one conservative there, more often than the conservatives are to ever be able to get one of the liberals to cross over and join them. So I think that's sort of an interesting data point that Gorsuch and Kavanaugh disagreed in 30% of the cases last term. And we hear a lot about 5-4 rulings. 5-4 rulings are not that common. They're on average 20 to 25% of the cases at the Supreme Court hears end up being decided by one vote. The vast majority are decided 7-2, 8-1, or 9-0. So for the most part, the justices are able to coalesce and come to more than just a bare majority when they're ruling.
And I think we see, and have seen even recently, the enormous respect they tend to have for each other as sitting on the court. I mean, even just recently, there was, very gracious words, I think, by Ruth Bader Ginsburg towards Brett Kavanaugh. I mean, that was a really interesting development. My guest today on the BreakPoint podcast is Elizabeth Slattery. She's a legal fellow and appellate advocacy program manager for the Meese Center for Legal and Judicial Studies at the Heritage Foundation. And we're talking about an overview of the Supreme Court's 2019-2020 term. I want to make sure you can find Elizabeth's terrific article, which you can find at heritage.org, or come to breakpoint.org. Click on the link there on the homepage that says resources mentioned on the radio and podcast, and we'll link to this article entitled Overview of the Supreme Court's 2019-2020 term by my guest today, Elizabeth Slattery. We started out, Elizabeth, talking about what really has been the context for most of the religious freedom issues that we've seen at the court, which is the collision with sexual freedom. But there is a decision from a few years ago, an Alliance Defending Freedom case, Trinity Lutheran versus Comer, which came out of whether state funds can be used for religious groups. And, of course, strict separationists between church and state would say no. We've got another case on the docket. So this doesn't really have to do with sexual freedom or the LGBT challenge. This has to do with basically this so-called wall between church and state that both the left and the right see very differently. So we're talking about another case here, Espinoza versus the Montana Department of Revenue. Talk us through that one.
Sure. This is a very important case. It involves a Montana law that set up a tax credit program so that people, if they decided to make a donation to this scholarship fund, they would get a $150 tax credit. And the scholarship organization would give those funds to income-eligible children to use at private schools of their choice. So families would apply for their children to receive a scholarship and then decide what private school they wanted to use those dollars at. So about as indirect as you could get from the state giving money directly to a private school, but the state initially allowed parents to use these dollars at religious private schools. And after the law went into effect and parents started to take advantage of this, Montana realized that, well, they have this state constitutional provision called, it's known as a Blaine Amendment. 37 states have these that prohibit public funds from aiding religious organizations. And so, these Blaine Amendments were passed for the most part, in the late 1800s. They were intended to target and prevent public funds from going to Catholic schools, because at the time, public schools, as they were, being developed, had more of a Protestant bent, and they didn't want public funds going to Catholic schools at that time. So, sort of Supreme Court justices, including Clarence Thomas, have written about this sort of ugly, discriminatory history of these Blaine Amendments, but nevertheless, 37 states have them in their constitutions to this day. So the state decided, well, we're not going to allow parents to use these dollars at religious private schools anymore. A group of families that had children who they wanted to send their children to religious schools challenged it. It went all the way up to the Montana Supreme Court. The Montana Supreme Court said, yep, we agree with Montana. This violates our Blaine Amendment. And the remedy was that the Montana Supreme Court decided to invalidate the program in its entirety. So no scholarship funds to be used at any private schools. And so that is what is at the Supreme Court. And the issue and how this ties in with the Trinity Lutheran case that you mentioned is whether this discriminates against the parents, the families that want to use these funds at religious schools, whether this violates their free exercise of religion. Now, in the Trinity Lutheran case in 2017, a majority of the Supreme Court said, by a vote of 7-2, said that Missouri had violated the free exercise clause when it would not allow a church-run daycare to apply for a public grant to resurface its playground with scrap tires. Missouri said, well, we're concerned about an establishment of religion here. And, if you think about using a public funds, a scrap tire program to resurface its playground, that gets about as far from what you'd consider an establishment of religion as I can think of. Establishment of religion, you think of the state telling you what church you have to go to, the state using state funds to directly pay ministers' salaries and things like that. But nevertheless, the Supreme Court agreed with the challengers and said, you can't discriminate against a church solely because of its religious identity. But Chief Justice Roberts wrote the majority opinion. He said, this is limited to playgrounds and resurfacing using public grants. Don't read anything into this, that this goes further than that. But now we have the Montana case, the school choice case, and so the challengers there are seeking to build on the foundation of Trinity Lutheran and extend it into the school choice area.
Yeah, that definitely gets a lot closer to what we might think about an establishment clause. Listen, we're almost out of time here, but one of the most interesting things that the Supreme Court's looking at is something that it hasn't looked at, as you write in your article, since 2008, and that's something having to do with, or 2008 and 2010, I guess, which has to do with the Second Amendment. So you think about all the cases having to do with the First Amendment, and as you write, or as Justice Thomas wrote, the Fourth Amendment, in recent years, the Second Amendment, this is as culturally controversial as it gets.
That's right. And, Justice Thomas has pointed out that in the decades since the Supreme Court has taken up a Second Amendment case, because it's been nearly 10 years since the last one, the court has routinely taken up dozens upon dozens of First Amendment cases, Fourth Amendment cases. But he says that the Second Amendment is sort of the orphan of the Bill of Rights. So the case is coming up. It's a challenge to a licensing regime in New York City, which limited individuals' ability to use. They have to apply for what's called a premises license in order to possess a handgun. And then when you get this license, you can only possess the handgun in your home or transport it to one of 7 gun ranges within the city. You couldn't take it outside of the city. You couldn't take it anywhere else. If you moved from one apartment to another, I guess you'd have to leave your handgun behind because there was no mechanism for moving it. So this was challenged. It was upheld by a district court in New York and then upheld by the Second Circuit Court of Appeals, which said that the regulations impose at most trivial limitations on the resident's ability to lawfully possess firearms for self-defense.
Yeah.
So it's now at the Supreme Court, but the city changed its regulations. So the court granted cert in this case last January, and the city's had plenty of time to get up to mischief. So they changed their regulations so that now people who have a premises license can take their handguns to a gun range outside of the city. They can take it to a new home if they move. But the challengers say, and so the city says, okay, the case is moot. There isn't a live case or controversy, which is a constitutional requirement for the Supreme Court to hear cases. The challengers say, look, we're looking for permanent, binding, forward-looking relief, telling the city that they cannot, after this case goes away, decide to reinstate their previous regime, their licensing regime. And so that's why they think that the court should reach the merits of the case. Of course, the city says there's no case anymore, even though they defended the constitutionality of their regime for 6 years in litigation. And then when it gets to the Supreme Court and they see that this might have broader implications for gun rights throughout the country, they decided to try to take the case away from the Supreme Court, which the justices tend not to like when parties do that.
Wow. Well, that's going to be interesting to watch, as you mentioned, opening day, which involves conversations about Obamacare and immigration, specifically the DACA program, which that's not controversial at all. And we'd love to get into that a little bit more, Elizabeth, but I appreciate you giving us the time that you have. And come to breakpoint.org, click there on the homepage on the button that says resources mentioned on the radio and podcast, and we'll link you to this really just terrific summary of what's on the docket for the Supreme Court in this 2019-2020 term, which begins on October the 7th. Elizabeth Slattery is a legal fellow and appellate advocacy program manager for the Meese Center for Legal and Judicial Studies at the Heritage Foundation. She researches and writes on the rule of law, separation of powers, civil rights, and other constitutional issues. And she has her close eye on the Supreme Court. And I imagine, Elizabeth, you'll be continuing to write legal analysis as this docket goes forward and decisions are made.
Yes, thanks so much for having me.
Thank you so much for joining us and for shedding some light on this.
That was Elizabeth Slattery of the Heritage Foundation discussing the upcoming session of the Supreme Court of the United States, a session that begins next Monday. Before we go, I'd like to remind you that the Colson Center is offering a book this month that explores more in-depth the issues John and Elizabeth discussed today. Free to Believe is a powerful new book by Luke Goodrich, an attorney for the Becket Fund for Religious Liberty, where he has represented Hobby Lobby and Little Sisters of the Poor before the U.S. Supreme Court. You can get this new book by Luke Goodrich by going to breakpoint.org and making a donation of any size to BreakPoint and the Colson Center. Again, that's breakpoint.org. I also want to let you know that we have a free online webinar with Luke Goodrich this Friday at noon Eastern Time. The Colson Center's Warren Cole Smith will talk with Luke about his new book, and there will even be some time for you to ask questions. The Colson Center's Warren Cole Smith will talk with Luke about his new book, and there will even be time for you to ask questions. To participate in this unique opportunity or to find out more, go to breakpoint.org and click on the Events tab at the top of the page. Thanks for listening to today's BreakPoint podcast. For the Colson Center, I'm Shane Morris.